I don't think Ty Cobb had to play 3 games back to back. But in any event, Your Honor, Jed Berman again. May it please the court and counsel, I'd like to reserve my 2 minutes if I can. This case, I represent Anna Michelle Mack, and as we've mentioned, she is an insurance agent that also works at the Beck Insurance Agency with Jennifer Falloon in Jacksonville. This case doesn't...
So she actually has a license?
Yes, her license differs from the other ones, though. She has what's known as a 442 license, which is a limited customer service representative. She, pursuant to that license, is only allowed to sell automobile insurance. She cannot sell the homeowner's insurance that became an issue in this particular case. Obviously, the Beck agency sells both automobile and homeowner's insurances. The issue in this case really is, how does a person obtain on-the-job experience in order to qualify to take the department's test for a 220 license? This particular case involves 2 customers, Nelson Yetman. He was sold a homeowner's policy and the AWAS Motor Club. And a second customer, Laura Brown, who apparently had a sale involved with her automobile insurance. The Yetman case involves both the sliding as well as transacting insurance without an appropriate license. The first issue, of course, relates to whether or not the sale of the motor club to Mr. Yetman, who bought a homeowner's policy, could in fact even be a violation of the sliding statute. As I pointed out in my brief, the sliding statute that was in effect at the time of this transaction in 2001 made it illegal to sell an ancillary product in conjunction with motor vehicle insurance. It did not say that it is illegal to sell an ancillary product in conjunction with any insurance. The department, as I read their brief, has admitted error. They said, while the department acknowledges that the ALJ did err by finding the appellant had violated the sliding statute in relation to the sale of the NSD contract to Yetman. However, it then goes on to say that, nevertheless, this is sufficient to prove, or the evidence was sufficient to prove, that Ms. Mack had been deceptive or was unfit to make this sale of this particular insurance. My reply to that initially is, if the legislature had decided that this type of a sale must be included in the sliding statute, that's the reason they excluded in 2003 motor vehicle from the sliding statute. As that statute reads now, it simply says any sale in conjunction with insurance where the customer is not given their informed consent or not told that it's additional product could constitute sliding. Nevertheless, looking at the Yetman...
So you're asking us to interpret the statutes to forbid a practice that would involve sliding these motor clubs on people who were buying automobile insurance, but would approve sliding them to customers who want home insurance. You believe that's a fair construction of the statutes?
I don't think the statute addressed the issue of sliding in 2001. It does now. But in 2001, it did not address the issue of sliding.
Well, what about these more general provisions about unfair trade practices and so forth?
I will address that at this point. What the evidence showed in this case and what was put into the recommended order is, with respect to, on the direct examination by Mr. Marr, representing the department, and Mr. Yetman testified to all of this. He was told of an additional charge for the NSD. This was disclosed when he paid for his main insurance. That Mack was the one who told him about the additional charge. That he got a receipt. That he went home and he discussed the transaction with his wife. Keep in mind, Mr. Yetman did not pay for the NSD contract the day he was in the agency. In fact, he came back 3 days later to make the payment. Now, I cannot believe that with that concession on direct examination by Mr. Yetman, that there has been proof by clear and convincing evidence that there was either deception or unfitness in the transaction with Mr. Yetman. So not only did that transaction is not covered by the sliding statute in effect at that time, but the evidence shows that Mr. Yetman, regardless of what he says after the fact, was explained what was being sold to him. He went home, he thought about it, he comes back 3 days later, and he pays for it. I don't think that that shows either unfitness or deception on the part of Ms. Mack.
Now, the department has argued that your first issue was not preserved for appellate review. How do you respond to that? Did you raise the issue of the definitional point in the statute below?
Yes, sir. My approach to that, Your Honor, is that to have been convicted of something that is not a crime is really fundamental error. And again, we have this Werner case about whether you are being convicted of a definition or whether the definition is included into 626.6216 is a whole different issue. In this particular case, clearly, Ms. Mack, as with the other two agents, they have been convicted of violating a definitional statute. I don't think that that needs to be preserved. I think that it's just like being convicted of a crime that does not exist. And that at least mandates that this case be referred.
Maybe there was no objection below because, as Judge Van Nortwick suggested earlier, everybody understood the reference to the definitional statute as alerting, giving fuller notice to the licensee of precisely the unfair practices the department was seeking to discipline the licensee for.
In this particular case, I will acknowledge that the administrative complaint is clearly fuller than it is if you compare it to the administrative complaint in McDaniel. In McDaniel, all it says is you sold this without the informed consent of the customer. In this case, there are numerous charges that were leveled against Ms. Mack. That is, that she participated with another person in selling the insurance, that Ms. Mack did not know the underwriting guidelines when she was transacting insurance with Mr. Yetman, and several other violations. So there was a lot spelled out in the administrative complaint. The problem is that the recommended order only found that there was a violation of a definitional statute. And obviously we couldn't anticipate what the administrative law judge would do. We assumed that the definitional statute was something incorporated into the penalty statute, and yet we have a final order that convicts her of violating a definition.
Well, when you saw the problem in the recommended order, why didn't you file exceptions?
We didn't do it. There were other issues that we were more concerned about. That's the best I can say, Your Honor. Let me get to the real problem in our case here, and that is so whether or not Ms. Mack's activities with Mr. Yetman were sheltered by the statute that says you must get certain experience before you can even take the test for a 220 license. In this particular case, the statute requires that a person have responsible insurance duties as a substantially full-time bona fide employee in all lines of property and casualty insurance. Ms. Mack dealt with Mr. Yetman, according to our case, under the supervision of Ms. Falloon, who was a 220 licensee, and subject to the verification of her employer, Monica Beck, the owner of the agency. Our position is that based upon the statute and the evidence that was presented, what Ms. Mack was doing is simply obtaining experience with Mr. Yetman, that her activities with Mr. Yetman were sheltered. And last, there was an issue here as to whether Ms. Mack had knowingly assisted somebody else in the transaction of insurance.
You're not arguing that this penalty statute is vague, given the requirement that there be 1 year, at least 1 year in responsible insurance duties?
No. What we're saying is, and the department argued, she was already qualified. You didn't need to do this anymore. She had failed her test. I don't think anybody would want to go back and take a test a second time without obtaining additional experience. And that's what she was doing. I'd like to reserve the rest if I may, Your Honor.
May it please the Court, Rob Fox, Senior Attorney, Department of Financial Services. The Department used section...
How did the Department arrive at the penalty in this case, or how did the ALJ arrive at the penalty?
I believe the ALJ looked and found the sale of the ancillary product, the Nation Safe Drivers Homeowners Policy, to be in violation of 626, 611, subsections 5 and 7, and also those definitional statutes. Now, the department has said the definitional statutes were error. However, she's still...
Even if you take the violation of the definitional statutes out, don't the definitional statutes define sliding to only apply, at least as it existed then, to only apply to motor vehicle insurance?
At that time, yes. At that time.
So the definitional statutes are not only can they not be a basis under Warner, I guess it is, for penalty, but they offer no assistance to the department here under one of the other penalty statutes.
We still believe as a department that 611, subsection 5 and 7 could be used. Under subsection 5, you've got willful misrepresentation of any insurance policy or willful deception with regard to any insurance policy. And, of course, subsection 7 demonstrated lack of fitness or trustworthiness, and believe that the ALJ and the department could have used those subsections to penalize the agent in this case.
And how many counts are we talking about here?
I believe we're talking about 2. I'd have to review.
And is it 3 months as to one count and 9 months as to another?
I believe it's 6 months and 6 months on the 2.
Now, one of the counts was the failure to supervise Ms. Webster.
Yes, that's correct.
And are 6 months authorized by the penalty rule?
You're going to catch me on this one because I don't have penalty rules in front of me, so I cannot answer that question. I do apologize for that. Of course, the guidelines and the penalties imposed are explained, of course, in the department's final order. But certainly, I do want to address the point which what the appellants are making regarding the training aspect. Now, what we've got is...
Let me ask you a question to put that in not the negative light, but the positive light. You argue that the acts prohibited by 626.041 can't be done while gaining, quote, responsible insurance duties. But what exactly can a person do to gain those duties for this type of license?
Well, we've got Ms. Falloon, the 220 agent who was training or allegedly training the appellant at the time. Her testimony is to how she trains people holding lesser licenses than herself. And what she allows that person to do is to observe her, to watch her, to listen to her. And that would be acceptable training. You've got someone behind you, shadowing you, watching you. There's no exception under our statutes. If you are not licensed as a general lines agent pursuant to our code, you cannot act as a general lines agent. And that is precisely what the appellant, Ms. Mack, was doing in this case. She was acting as a general lines agent without a proper license. Now, again, the training aspect, you look at it, she was qualified to take the test. She was qualified, it looks like, about 1.5 years after even the Yetman transaction. Her qualifications would still be available to take that test. She may have wanted more training, but to claim she needed to be trained, well, that's just not the case.
Well, the statute says at least 1 year, so
yes.
The statute doesn't say only 1 year.
That's correct. You need at least 1 year to take the department's test. She had already qualified. She had already taken the test. Yes, she had failed it, but she was qualified to take that test and retry to pass it, and she did not need to be trained. What she was doing out there was operating as a general lines agent without a license.
You pleaded in one count the sliding and the unlicensed practice, or the practice outside the license restrictions. Yes.
And, of course, the penalty that will be imposed, as former counsel Mr. Bossert explained, you'll see the laundry list in there, 624 624.11 subsection 1, 626, 611 subsections 5, 7, 8, 13. You're going to see a laundry list of violations, but you're only going to see one penalty imposed, the highest penalty that can be imposed under the listed statutes. So even though, yes, there's multiple conduct that was included in that one count, you're going to see one penalty imposed, the highest penalty that can be imposed.
Well, does it matter for a licensee? In other words, if there's a basis to uphold a count on, does it matter for a licensee in the future what the basis on which the discipline was imposed? In other words, you're saying it does not matter in terms of the length of the suspension.
I think it could certainly, depending on what statute was used to impose the penalty. You're saying if something is done in a statute where it's a willful manner, perhaps to another statute where it's, non-willful. Of course, the penalty itself is the time frame. The violation is still there for all these other statutes. So when they're coming back to either be reinstated or to apply for another license, they still have those findings that they did violate these other sections of the law. It may not have been the one used to, for the time frame itself, but they still are.
I guess I don't understand if the penalty rule is you take the highest penalty for any violation pleaded in a particular count. I don't understand why you don't plead multiple counts. Instead of, it looks like a dozen violations in a single count.
I would have to say just the style of the department's administrative complaints across the board. That is the style and the manner in which it is done. And of course, we are here now. You're saying you've got 6 violations or 5 violations under count 1. Only one of those violations is being used to impose the time frame, but those other violations are still on the record. They still will be considered when someone comes back seeking to be reinstated.
All right, so if we find that a ground for a violation found in a count is not established, what is the appropriate relief?
I would suggest that the court remand it to the department, because especially in this case where you have, as I was going through the laundry list of violations, there will be, in I'd say 9 times out of 10, a violation that will be supported and will be used to impose a penalty.
So what is it we're reversing? Are we reversing a ground?
It would be you would be reversing a, I guess it would be a ground. It would not be a count. It would be a ground. One of a larger pie.
Well, I don't want to speak for my fellow panel members, but that we don't really, I don't think of us as being in the business of reversing the reasoning or the grounds in general, but.
I know, and of course the standards are if there's any ground available which would support a final order, it should not be. And clearly they are outlined in the brief. I do have all those standards in there.
Right, that's the general rule.
Yes.
But you're saying that in a case like this, if we see a ground that is unsupported.
Well, you could use a general rule and simply say that if you have support for any other count, not any count, any other ground within the final order, and it's not going to affect perhaps a time frame that's involved, we're not talking the 9 months to 6 months or 6 months to 3 months, then the order should be upheld. It should not be remanded. I mean, I think that would be the cleanest and the easiest and probably.
What I'm struggling with in that regard is the findings of the administrative law judge, and I'm looking at paragraph 39, really seem to relate mostly to the definitional statute on slide. It makes a reference to violations of any number of sections, including the ones you discussed, 626, 611, 7, and 8, but doesn't really say how the facts constitute a violation of those sections. The findings really relate to the definition, which we all sort of, I think, agreed doesn't apply for 2 reasons. So what do we do with that? I mean, that's the concern I've got.
Well, you still got...
The findings don't, he has found a violation, but we have no factual finding related to that.
Of course. course, you have two grounds in there, one being unlicensed activity, the other being the sale of that ancillary product. Again, subsections.
I was just referring to the answer.
Yes, okay, subsection.
That paragraph deals with the other. I'm not.
I'll quickly say subsections 5 under 626, 611 again, subsection 5 and 7, general violations, general statutes, and certainly if you're selling an ancillary product and you're not allowing informed consent, you're looking at the Thomas case, you're looking at the general violations, not necessarily sliding in particular, but those general violations can support the violation of the failed or improper sale of the ancillary product. Thank you.
All right, thank you. We let you go about a minute over, so let's add a minute to Mr. Berman's time.
Your Honors, a couple of items I want to respond to. One question that was posed to counsel is whether on the Webster count there was a failure to supervise. The administrative law judge found that there was no obligation on the part of Michelle Mack to supervise Ms. Webster. So I think that is beyond the final judgment or the order in this particular case. What the administrative law judge said is that Ms. Mack willfully aided somebody else in the transaction of insurance. What I would refer the court to is that apparently the administrative law judge forgot what he wrote in the recommended order in Falloon. In the Falloon case, he says, Anna Michelle Mack transacted insurance business with Laura Brown on January 22, 2002. Laura Brown was the one mutual customer that involved Falloon and Mack. So clearly, if he made the finding in the Falloon case that Ms. Mack was transacting insurance with Laura Brown, I don't think he could then find in the Mack case that Mack was willfully assisting an unlicensed person to transact insurance with Ms. Brown. Also, the evidence was that Ms. Mack testified, I did deal with Ms. Brown, whereas Ms. Brown testified, I never saw or I never dealt with Ms. Mack. I don't know which party to believe, but in either case, there cannot be a conclusion that there was willfully aiding somebody to violate or to transact insurance. Also, the question was, what can you do to learn how to become an insurance agent? The problem is that the department has no rules regarding the training of a person in an insurance agency. In this particular case, we have the licensed person, Falloon, saying that she supervised Ms. Mack, and we have the employer saying, I'm verifying that there was supervision done. In the absence of any rules from the department as to say what you can do and what you can't do, I think it's probably an opportunity for the court to say, here's how you can do it. Or, at least in this case, there was no violation. Or, in the worst possible case, at least in this case, there was. But the evidence also showed that Ms. Falloon was involved in the Yetman transaction. She was the one that did the evaluation or the valuation of his mobile home because Ms. Mack had no ability to do that. Thank you very much.
Thank you. The court stands in recess.